Great. It's 8:01 by my clock, so I'm going to go ahead and kick things off. Good morning, everybody, and thank you all so much for joining today. My name is Emily Johnson, and I'm the Colorado Health Institute's Managing Director of Research, Evaluation, and Convening. I believe I've worked with many of the folks on this webinar over my 10 years at CHI, but I also know that we have some new people attending, so welcome. We have all spent the past few months focused on the presidential election, and that's now less than 2 weeks away. But today we're going to highlight a part of federal policy that is going to be important no matter who sits in the White House, and that's the Supreme Court, specifically how some of its recent rulings could play out in Colorado and what our state leaders can do about it. Before we get into the content, just a little bit of housekeeping. We will have time at the end of this webinar for questions and for discussion. You can enter questions using either the Q&A button or the chat on Zoom. And at that time, we'll also encourage you to raise your hand so we can bring you off mute to ask your question out loud. I'd like us to all try out the chat function quickly just to make sure it's working. So if you could, please just share a word or two about what you're doing to stay grounded during these nerve-wracking times. Right, I'm seeing muting TV commercials, smart, long walks, always great. Deep breathing and disconnection from social media. Pets, yes, huge. Today there was a beautiful sunrise. All right, I feel like the theme I'm seeing is like getting some exercise and self-care going, and then also trying to ignore the things that we know are bringing some of this nerve-wrackedness into our lives. So thank you all for sharing that. I'd like to share a bit about who the Colorado Health Institute is, just for those of you who might not be familiar with us. CHI is a nonprofit, mission-driven public health institute. We strengthen communities and systems with trusted analysis and collaborative solutions to improve health. We've worked with community groups, providers, state and local government agencies, and foundations for more than 20 years, providing that trusted analysis and data, strategic planning, facilitation, complex modeling, evaluation, and strategic communication. In addition to our counseling work for organizations that share this mission of advancing health equity, we have a public-facing portfolio of work that is funded by philanthropic supporters. If there's anyone who would like to learn more about CHI after today's webinar, I'm always happy to connect if you want to just talk about how CHI can support your work. This fall, CHI is closely following the election, as I'm sure most of you are. Today's webinar is the second of 3 events on the topic. Last month, we looked at the importance of democracy to public health, and in December, our Hot Issues in Health conference will look back at the election and ahead to the 2025 legislative session. There are still some tickets available, so if you haven't registered for that conference yet, I would encourage you to do so quickly. We do have early bird rates available through the end of the month, and our scholarship deadline is also coming up. And now I will turn it over to Joe Hannell, who is our communications director, to kick off our content for the day. Joe.
Thanks so much, Emily. As she said, I'm Joe Hannell, communications director at CHI. I'm in my 10th year, well into my 10th year at CHI, working on the legislative portfolio. And for another just about 10 years before that, I was a reporter at the state capitol. So politics has been in my career for way longer than is healthy. I definitely have to thank a couple of colleagues, Gerardo Silva Padron and Kimberly Fu, who did a lot of the research that you are about to see me present. So what we'll do today is I will provide a little bit of level setting on what the Supreme Court has been up to. Then we've got 2 excellent guest speakers who I'll introduce in a minute. And then at the end, we will have plenty of time for discussions and questions. Again, I encourage you to use that raise hand function so you can come off mute and talk to our panel altogether. Emily is going to be joining us again for that panel. Our guest speakers today are Rosalie Winn, Director and Lead Counsel of the Methane and Clean Air Policy team at the Environmental Defense Fund. She's here in Colorado. And then we have Professor Leo Cuellar from Georgetown University's McCourt School of Public Policy. Professor Cuellar could not join us live, but we think what he had to say was an important enough take on this issue that we pre-recorded an interview with him. And I'll be playing that right after Rosalie speaks. So let's get going with a little bit of talking about what the Supreme Court has been up to. This is your Supreme Court. These 9 people, the newest justices, are in the back row. Trump's 3 appointees are Justices Barrett, Colorado's own Neil Gorsuch, Justice Kavanaugh, and then President Biden's only appointee is Justice Brown Jackson. Seated in the front row on either side are Justices Sotomayor and Kagan, both appointed by President Obama, and in the middle, 3 Republican appointees, Justices Thomas, Chief Justice Roberts, and Justice Alito. This group has made some really consequential rulings and decisions in the past few years. Of course, in 2022, they overturned the nearly 50-year-old Roe v. Wade precedent that allowed states to outlaw abortion. That was a 5-4 majority made up of these justices. Chief Justice Roberts didn't want to go quite so far as scrapping Roe. But just this year, the court issued several more controversial rulings. And you often saw the 6 conservatives in majority on those. On one of them, a case from Grants Pass, Oregon, it allowed cities to enact camping bans for homeless people. And we're already seeing that reverberate here in Colorado. Douglas County cited that ruling this fall when it passed a camping ban. But the ruling we're going to spend most of our time on today also came from that 6-3 majority in a case called Loper Bright Enterprises, that is better known as the Chevron case. That's because this case overturned a 40-year precedent that came from a case called Chevron versus Natural Resources Defense Council. The precedent helped establish the modern administrative state, that there's thousands and thousands of civil servants or bureaucrats, scientists, whatever, that make up the federal government and make it run in our very complex world. It did that by setting the precedent that when the law is unclear, judges should defer to the expertise of those federal administrative agencies. We're talking like Environmental Protection Agency, Department of Health and Human Services. When someone sued the government over one of those agencies' decisions, the only thing judges had to decide was whether the agency had legal authority to make the decision and was it a reasonable decision. Without that precedent, new cases won't pay the same deference to agency experts. Colorado Attorney General Phil Weiser has said this could make each new case a jump ball. And several of us at CHI attended a talk from the Attorney General a couple of weeks ago. I think one of my colleagues is going to put a transcript of his speech in the chat in a few minutes here. It's worth a read. Now, importantly, this Loper Bright Enterprises case applies to federal agencies, not state agencies, and we'll see why that's important in a minute. And then fun fact, the original Chevron case was about setting pollution standards, and the oil company in that case, Chevron, actually won. The government had made an administrative decision that the environmental group didn't like and sued, but the Supreme Court said, we need to defer to the agency on this. It worked out very well for the oil company in that case, even though it has come to groups in favor of cleaner air, cleaner water, have come to rely on the ruling a lot more recently. So that's a lot of legal mumbo jumbo. Let's just take a little bit of a cheeky look at how this works. So imagine there's an industry that is polluting a lot. People don't like it, so they complain to Congress. And Congress says, hey, executive branch. Yeah, what's up? Congress says, you've got to do something about all this pollution. The executive branch says, on it. And the president speed dials the EPA. And he calls and says, hey, EPA, Congress says we need to clean up the air. Yes, you see? Okay, I'll ask them. Hey, Congress, they want to know how many parts per million is acceptable for ozone precursors. What do you want? Congress says, do we look like organic chemists? We don't know. Just ask your smart people what would make the air cleaner. Can do. And now up pops, hi, I'm Supreme Court Justice Elena Kagan, and I think this is exactly how it should work. Congress should give up the executive branch legal authority to clean up the air, but the scientists should handle all the sciencey stuff. Excuse me, I'm Chief Justice John Roberts, and I don't like that system. We're going to change it so that judges must use their independent judgment and not defer to the scientists for the sciencey stuff. This is about the law. If Congress wants to do something, they should pass a law. And Congress says, seriously, have you seen us recently? We can't even agree the sky is blue. And there's a lot to that. So in an ideal world, maybe our elected representatives in Congress would make more decisions instead of elected civil servants. But like our animation said, have you looked at Congress lately? At the same time, the world's getting more complex. Just artificial intelligence alone is a hugely complicated topic. Congress is passing fewer bills than ever. This is a graph from Axios that shows bills passed by Congress since the late 1980s. That last little nub there is the year 2003. Now, to be fair, that's only 1 year into the term, but even when you look at it, if we would do this graph just based on the first year of a term, that would be a lot lower than any other Congress. So 2024 also has not really been a fireball of productivity for Congress. In fact, Congress is in recess until after the election, and it's only been in session for 3 weeks since the end of July. In other words, Congress is just not going to be able to pass bills that provide clear, detailed direction to the entire federal government. So where does that leave us? Well, a lot of legal scholars would say not in a good place. Here's a Yale law professor who says there's a real risk of regulatory chaos. Here's another one who said it'll be hard for government agencies to be innovative. So think about Center for Medicare and Medicaid Innovation, whose sole purpose is to come up with new ideas. Here's another who says the ruling cracks the foundations of environmental and public health protection. Strong words, but an important thing to remember is that overturning this Chevron precedent opens the door for new lawsuits on any past decision that relied on Chevron. And there's 17,000 of those. So that is really the foundation in legal case law of our current environmental and health protections. So what's that mean for Colorado? We'd be lying if we said we knew the exact answer, but we can look at areas of risk, or as we think about it at CHI, like exposed surfaces where something that happens in the federal government might have an effect here in Colorado. We think a lot about air and water protections. Those are all handled through the Colorado Department of Public Health and Environment. They have boards that set standards for air quality and water quality, but those are grounded in federal law. Another way that CDPHE works a lot with federal government is its funding. Last year, more than a third of its funding came from the federal government. A lot of that to carry out regulation of air and water pollution. Another area where the state overlaps a lot with the federal government is Medicaid. It's run by the state, but it's a joint federal-state program, and the state needs federal approval for a lot of the things it does, including waivers to expand certain types of coverage. We are already seeing the effects of the Chevron decision in healthcare in some important ways. One of them is this summer, the Department of Health and Human Services passed a rule to interpret the Affordable Care Act's ban on sex discrimination in healthcare to include gender identity. But a federal judge in Mississippi blocked that rule this summer, and he cited the Supreme Court's decision in the Chevron precedent. So that's an overview of our risks. What can we do now to cover these exposed surfaces? First of all, just simply be mentally and administratively prepared for delays from federal agencies. Things just might not work as quickly as we were used to. Second, the Chevron doctrine did not apply to state agencies, so Colorado can pass or strengthen its own pollution rules, for example. Great example of that is a couple of years ago, the state legislature passed minimum standards for pollution of these so-called forever chemicals, or PFAS. Don't ask me to pronounce what the actual acronym stands for. This course of action, though, it continues a trend we've seen over the past 15 years of states setting different policies. It started with the Medicaid expansion of the Affordable Care Act, or probably goes back before then, but really got going under the Affordable Care Act. We're seeing 50 different state rules on abortion. We're probably going to start seeing it more in environmental rules, maybe even more in healthcare. That's just going to be a consequence of states stepping in if they want, or to cover up federal government omissions, or places where the government can't step in because it's kind of hamstrung by court rulings. So with that, we're going to turn it over to our speakers. First we'll have Rosalie Winn from Environmental Defense Fund talking about some of the environmental implications, and then we'll hear from Professor Leo Cuellar, and he will talk a lot about Medicaid. So Rosalie, I'd like to turn it over to you. Thank you.
Thank you so much, Joe, and thanks to CHI for having me here today. I'm really excited for this discussion. Also appreciate all the ideas in the chat for ways to stay sane during election season. Personally, I've been having a lot of dance parties with my toddler, who is in her Frozen music era, so that's been a good distraction. So a little bit about me, as Joe mentioned, I'm a director and lead counsel at Environmental Defense Fund based in Denver. I work on climate and clean air issues with a focus on reducing emissions from oil and gas and other industrial sectors. And I primarily work on federal policy and strategic federal litigation. So a little bit about EDF. For those who don't know us, we're a global nonprofit, although we have a strong Colorado presence. And our mission is ensuring a vital Earth for everyone, with a focus on tackling climate change as one of the biggest issues that our world is facing. So today, I'd like to provide a kind of quick overview, building on Joe's remarks, of how the Loper-Bright decision is playing out in litigation so far. And then would like to shift to how federal agencies and interested stakeholders can respond to the decision and work to build legal durability into new federal rules. And then finally, would like to talk a little bit more about impacts for states like Colorado. So what's the litigation landscape look like after the Loper-Bright decision overturning Chevron? So we've already seen Loper-Bright cited in dozens of court decisions in the federal courts, and many, many more legal filings. We've seen that courts have declined to defer to agency interpretations in a number of cases and have relied on Loper to vacate or overturn agency rules. Oftentimes, courts will kind of step in and say that the agency's interpretation of a statute, though under the Chevron scheme, it might have been considered reasonable. It's not the single best fixed interpretation of the statute as demanded by Loper, and the court will say, in our judgment, this is what the best interpretation of the statute is, and what the agency has done is not that. so they will strike down the rule. In other cases, courts have found that agencies still receive some other forms of deference. So for example, courts have found that agencies still receive what's called our deference, or deference to how an agency interprets its own previous regulatory language as opposed to language in statute that's been passed by Congress. And courts have also invoked Skidmore deference. So under that scheme, a court will look to an agency's interpretation to provide expertise and informed judgment, but ultimately, it's the court's call. And then in some instances, we've seen courts decline to review or disturb prior case law, relying on Loper-Bright's language that it is not intended to call into question the 17,000 cases previously decided under Chevron, or open the door to relitigate longstanding interpretations. I think that is going to be kind of a court by court determination how that sort of actually plays out. But we have seen some courts decline to look back at prior regulations that have previously been upheld. And so across the board, what we're really seeing is a wide variation in how lower courts are treating the decision. Some district courts and circuit courts, particularly those in the Fifth Circuit, have been quite aggressive in applying Loper-Bright to substitute a court's view of the statute for the agencies, while we've seen some other courts like the DC Circuit be more measured in how they're applying the decision. I think ultimately, what will happen is that Loper-Bright will accelerate and drive forum shopping, or for opponents of a rule looking to bring challenges in very specific courts where they think that they'll have a better chance before the judges in getting a rule overturned. So that forum shopping trend has been something we've seen over the last 10 years, but I think this is really going to supercharge it. So how can agencies kind of respond to this new landscape? So for that, I think I want to highlight a few areas where agencies still have some room to operate even under the Loper-Bright decision. And so there are kind of specific areas where oftentimes the statute will grant discretion to an agency clearly, and agencies can really leverage that sort of more explicit area of discretion in terms of how they are regulating. So first, statute might grant agencies express delegation or expressly delegate agencies authority. So for example, a statute could direct an agency to define a term. Next, a statute could direct the agency to provide a overarching scheme, but direct the agency to kind of fill up the details of how to regulate. And then finally, there are kind of broad statutory terms that a court should recognize as granting an agency to set considerable discretion to act. So terms like appropriate or reasonable, establish appropriate or reasonable regulation. Those should still grant agencies a measure of flexibility. Agencies can also help explain their history of regulation and how an action that they're taking now is consistent with their past actions. This will also help guard against another sort of new Supreme Court doctrine, the major questions doctrine, which the Supreme Court established in a 2022 case, West Virginia versus EPA. There, the court overturned an EPA rule designed to reduce carbon pollution from power plants, saying that it was a major question and Congress needed to speak very specifically to regulations that would have sort of vast economic or political significance. So for an agency to explain how what it's doing now is tied to and consistent, building upon what it's done in the past, that can help guard against major questions risks as well. And then finally, agencies can characterize agency action as a factual decision. Typically, factual decisions under the Administrative Procedure Act are upheld if they're based on substantial evidence. Or an agency can characterize its decision as a policy choice, which should be upheld if it's reasonable or reasonably explained. This is the arbitrary or capricious standard. So if an agency action is not arbitrary or capricious, it should be upheld. So characterizing actions as factual or policy choices rather than a legal interpretation that would be reviewed de novo or upon first look by the court can help build some legal durability as well. And I think outside experts can also support building this durability by participating in public comment periods to help build a robust administrative record for a rule. That record will be the basis for the agency action and will be closely reviewed by a court in litigation. So outside experts can help develop the factual support for the action that the agency is taking, helping to build that substantial evidence to support a choice. And then outside experts can also help support an agency's position as consistent with legal authority and past regulation. So for example, oftentimes EDF, when we're commenting on a new environmental or climate standard, will provide overview of how the agency is regulated, under that statutory provision in the past, and how explain how the agency's action here kind of ties into that history. All right. And then finally, just wanted to build a little bit upon Joe's remarks about state impacts. As Joe noted, Loper-Bright does not disturb state deference schemes where state agencies may get some level of deference under state law. And we've also seen states respond to recent Supreme Court decisions impacting the environment with new legislation or regulation. And I think we could see something similar with Loper, where states might strengthen, for example, their state deference schemes, or more explicitly grant or empower their state agencies to kind of take protective action. One kind of additional example of Colorado responding to a recent Supreme Court decision is just this year, Colorado passed state legislation to protect wetlands after the Supreme Court's 2023 decision in Sackett versus EPA, which undermined the scope of the Clean Water Act. Sackett kind of carved wetlands out of the federal Clean Water Act, and so Colorado stepped in to fill that gap in the state. As Joe mentioned, we're also seeing this play out with state responses to the Dobbs decision on abortion, kind of cutting both ways in terms of how states are responding to that decision. I think unfortunately, by resorting to a state-by-state approach, this kind of is going to create a patchwork, which in the environmental space is going to undermine the cooperative federalism goal of statutes like the Clean Air Act and the Clean Water Act, which really fundamentally aim to set a federal floor for action to ensure that there's a strong baseline for protecting the environment, for protecting people, and kind of a state-by-state response lacks that federal baseline. I think this is especially important for issues like climate pollution, which of course transcend state boundaries. So maybe I will wrap it up there and look forward to taking questions. I'll turn it back to Joe.
Introducing yourself and tell us a little bit about your field of study.
Sure. As you said, my name is Leo Cuellar. I'm a research professor at the Center for Children and Families, which is known as CCF at Georgetown University's McCourt School of Public Policy. And CCF is a policy and research center focused on access to healthcare for lower to middle income children and families, of course. And CCF, much like my personal background, is less academic, and more based in actual practice, developing actual recommendations for real government healthcare proposals. I'm trained as a lawyer. I've done all kinds of work in Medicaid, from direct representation of people being denied healthcare to ACA implementation, to being part of a nonprofit legal group that litigated and blocked harmful Medicaid policies proposed by the Trump administration, including work requirements in Medicaid. So my world is Medicaid, and I work on it from both a policy and a legal perspective.
I'm really interested to learn what you see in Medicaid as the possible impacts of this Loper-Bright ruling.
Right. So the important thing to understand is that the Medicaid statute, the laws passed by Congress that are the basis for Medicaid, they don't have a lot of details. They say people should get Medicaid with reasonable promptness. But what does that mean? They say pilot programs must promote the objectives of Medicaid. But again, what exactly does that mean? And so it's really the body of regulation and other policy guidance created by the agency. In the case of Medicaid, that's Health and Human Services, that really puts meat on the bones. So we're talking about regulations and other form of guidance issued by the agency that really make the program work. And what we care about the most is they make the program actually work for the enrollees so that they can actually get the healthcare they need when they need it, as they are supposed to, as they are entitled to under the law. And you could make the same point about Medicare or the marketplace health coverage, and you could make analogous points for other agencies and the programs that they oversee. And until Loper-Bright, the agency had flexibility, right? It got judicial deference to build on what that skinny statute from Congress says, right? And Loper-Bright retracts some of that flexibility. So you can think about that meaning first. Things that are currently built, CMS policies in place that protect, that set standards for Medicaid, are at greater risk of being struck down through lawsuits. Second, CMS is going to be wary and going to be slowed down. They're going to be subject to lawsuits when they try and create new policies. So ultimately, if you care about access to healthcare, right, you want an agency that can keep up with changes in healthcare, right? Medicine evolves. Medical technology actually evolves super fast. And in any case, way, way faster than Congress is able to legislate. And you want an agency that can develop policies to make sure that naughty states aren't cutting corners while they pocket Medicaid dollars, that Medicaid managed care plans aren't denying people health care, and ultimately Congress's law does what it was intended to do. So the Loper-Bright case is an attack on the obvious fact here that to provide a functional health insurance to 80 million people in Medicaid and 50 million in Medicare, millions in the marketplace, we need an agency running the program with the power to adapt, to be nimble, to develop solutions and fix problems.
Given that, but where do you see this going over the next few years as those tough questions come up?
Right. So let me lay out two basic reasons that I think Loper-Bright might not do as much damage as many thought at first glance. First, Loper-Bright, it does kill Chevron deference. But Chevron deference to agencies applied in a specific scenario when an agency was making an explicitly legal interpretation. But agencies do a lot of things that are not legal interpretation. They do fact finding. They develop policy where they apply facts to law that's not in dispute. And to my knowledge, every agency, and certainly this is true for HHS with Medicaid and other programs, those agencies, there are broad areas where Congress has explicitly empowered the agency to make decisions. Even in the Loper-Bright decision, the Supreme Court recognizes that. And in overturning Chevron, Loper-Bright does not speak to those situations. So I'm saying that sort of technically, Loper-Bright should only apply to a subset of agency actions where the agency is trying to interpret the law. And since we know that, and the agencies are aware of that, when we're talking about, for example, covering some new drug and the question of whether or not Medicaid can cover that drug, we will try to characterize that, and hopefully the agencies will, based on those other types of agency actions that aren't harmed by Loper-Bright. So that's the first point. The second point is that the legal reasoning in Loper-Bright, is, in my opinion, weak. But setting that aside, it's also just not a very helpful case practically. The Supreme Court lives in this sort of fictional fantasy land, and they actually say this in their opinion, where they think that every law Congress writes has one single discernible legal interpretation, and the court can just, do their legal analysis and figure it out. But imagine that you are the judge, and you have to decide how fast is reasonably prompt processing of a Medicaid application, right? And there is an agency that works with states on setting up their computer systems to process applications and understands what states are capable of and what they're not capable of. And that same agency did a comment period where they got input from states and policy experts like me telling them, here are the different health impacts of the different options, and from a zillion other stakeholders who all have actual knowledge about application processing in Medicaid. And the agency, looking at all of that, came to the conclusion that 45 days is the right answer. What are you going to do as the judge, right? You're going to say, I have no idea what the answer is here, but was this agency's process and conclusion reasonable considering the law? And what is that? That's Chevron deference. So Chevron deference wasn't just the right answer legally, it's just also the one that makes sense in practice. And it's established in case law, including in Loper-Bright, that courts can choose to defer to agencies. Loper-Bright just says they aren't required to defer. And so even with Loper-Bright, more often than not, courts will choose to defer because often there is no one magical legal answer out there and they have no idea what the answer is. And that's not me saying Loper-Bright won't cause problems, right? It's a terrible decision. It's going to cause problems, but I don't think the world is going to implode here.
What can groups like the Colorado Health Institute do and other folks watching today? What can the Colorado State Legislature do and our state agencies to make sure that these regulations that they've built up for the past 40 years continue to function?
The law that governs at the federal level is the Administrative Procedure Act, the APA. And it sets out a lot of standards for evaluating the reasonableness, the validity of an agency action. But a core basic standard is, was that agency action reasonable based on the evidence that the agency reviewed at the time it made whatever the decision is? And so policy experts have a real role to play in compiling evidence and sharing it with federal agencies, getting it into that administrative record. And this can be both defensive and offensive. Let's say there's an agency action, a regulation that you want to protect. And you get a lot of evidence into the record showing that it is the best policy. If the agency is sued by someone trying to kill the regulation, your evidence will support the reasonableness of the agency's regulation. Likewise, if a bad agency comes along and wants to pass a bad regulation or repeal a good one, and you put evidence in showing why their policy change makes no sense, then when they go ahead with the policy and someone drags them to court, they can tell the judge, look, this agency's action flies in the face of the evidence they got at the time from experts. And that is actually exactly how we blocked the work requirements in Medicaid. Policy evidence can influence the reasonableness of the agency action under the APA, and this will be the legal standard in many situations where the courts are supposed to defer, and it will be the lifeline judges rely on when they are not required to defer. So my takeaway message is, don't waste your time trying to guess when and if and how often the courts will officially defer. Use your time to build the record that will be influencing them legally and practically most of the time, maybe almost all of the time. as a final point, on the topic of sort of what your state can do, one of the things you can do is look at federal policies in Medicaid that you think are really important policies that might be at risk of being attacked in the federal courts, and try and actually create state law and state policy enforcing those standards, so that if they disappear at the state level, some minimum standard disappears at the federal level, you still have your state standard there in place to protect everybody in your program.
All right, well, big thanks to Professor Leo Cuellar. I'm going to bring back Rosalie and Emily right now, and we can talk about some of what we've heard and what we've been talking about this morning. I was looking at the attendee list here, and there are some fantastically smart people in the audience, also people who I know are not particularly shy. So please funnel those questions to us, and we'll get going with. I'll pitch one right now to Rosalie. What is there something specific here in Colorado regarding air or water pollution that you think might be really a priority to look at? I know you work a lot on methane, and we have done a lot on methane regulation here in Colorado. Is that something you feel is at risk, or where's your attention right now?
Yeah, I think Colorado is very well positioned, actually, is among the states to kind of do what it has been doing in terms of leading on developing state level regulatory protections for sectors like the oil and gas industry. We've seen Colorado has actually, in the oil and gas space, kind of served as a regulatory model for the federal government. So EPA just last year issued federal regulatory standards for oil and gas sector methane pollution that all states will have to take steps to implement through a state planning process. And Colorado is kind of well ahead of the curve, and that much of what is in the federal regulations is actually kind of built on what the state has already done here. So I think in some spaces like that, I think Colorado, it's important that Colorado kind of continues to do what it's been doing and lean in on developing state regulatory protections. I think where there's more risk is kind of what happens in other states that don't have a history of strong leadership on these issues. And when you're dealing with a pollutant like methane that is a global pollutant, doesn't respect state boundaries, what is happening in other states is going to be really critical to ensuring whether Colorado can meet its goals.
All right, thanks. I know we're trying to get Monica on audio here to ask a question, but actually, are we on? No. All right, well, I will I've got a question for Emily then. We're a state health policy institute. You and I worked at CHI for a decade together almost. And all of this all this federal talk it's just a little bit beyond what we're used to. But at the same time, all the states kind of like drifting apart, and Colorado being kind of an island in the Intermountain West in a lot of cases. What kind of implications do you think that might have as we go on through the next few years?
Yeah, so Rosalie and Leo Cuellar both talked about some types of decisions kind of like that sort of abide by state boundaries and certain types of decisions I think that don't. And I think in the environmental space, like there's certainly a lot more in that not abiding by state boundaries section. In the health space, we're a little bit split. So this idea of how can, like, states can sort of structure their own Medicaid programs, for example. Medicaid is by far the largest, like, single provider of health coverage in the state of Colorado and in many states. And what we consider to be these reasonable processing times and how we're structuring that program is still kind of within our state control, regardless of what we're seeing happen in some of these other states. If I think about some of the things that have been big in public health recently, I would be remiss not to mention COVID, where we were seeing a lot of policies made at state levels and even sub-state levels, at really like local levels, county levels. And there was this sort of rush to balance the decision-making power of, you know, county commissioners and governors and the White House, the executive branch, et cetera, with rapidly evolving expert advice from public health officials, from epidemiologists, from infectious disease experts, et cetera. And I think that that is an instance where, you know, respiratory illnesses don't really obey any boundaries, state or county. And I don't know that I would go so far as to say Wyoming's policy had a direct impact on you know, like the level of disease spread in Colorado. But I do think if we're looking at this on a national scale, like that's an international scale even, like that is frankly like something that happened. And so I think it's sort of a question, and this is the theme of this conversation really, is like, what are those items that are within our control and what are those items outside of our control? And I think that our role as a health policy institute is going to continue to be to think about which lives where and where does our voice like live within the state, and then where do we live outside of the state in those examples. And so yeah, that's kind of a it depends answer, but I think that that's the theme of this, is that it depends, and we don't always have you know, like the impacts of that deference kind of depend on what issue we're talking about. So
Yeah, it depends, and I like your framing. And first thing we can do is figure out what's in our control, and then figure out what to do about it. And the stuff that's out of our control, you know, there are other ways to deal with that, like beautiful sunrises and long walks and all the things we saw at the beginning of the webinar. Great. Thanks. I think we're ready for an audience question for Monica. Monica, you're on when you're ready.
Sure thing. Monica Van Buskirk from MAP Policy Analysis here. And Rosalie, one of the things that struck me while you were speaking was that you gave some examples of how agencies might frame some of their guidance or how to leverage Skidmore. And I was curious if there are any examples of where those tactics have or have not been used successfully in other states.
Yeah, that's a great question. I am not so sure about in other states, but I think at the federal agency level, where we've already been seeing agencies kind of using some of those strategies even before the formal decision in Loper Bright. I think a lot of folks in the federal government and outside of it sort of saw the writing on the wall for the Chevron doctrine. You know, even though the doctrine formally wasn't overturned until this past summer, the Supreme Court hadn't, you know, cited it in a majority decision in years, even when it would seem to be relevant. Lower courts were also already in many instances kind of turning away from applying that level of deference. And so I think agencies in even many of the roles that the Biden administration has been working on did not explicitly rely on or anticipate receiving that level of deference. And so they've already been kind of shifting their approach into explaining why, you know, a term, why their actions are grounded in facts, and kind of explaining why they're policy conclusions rather than sort of relying on legal interpretations. And so, you know, I think we've we've seen that, for example, in the EPA oil and gas methane standards that I just mentioned. There's very little statutory interpretation in that final rule. Instead, the agency, very carefully explained how the standards that it is applying now are grounded in their long history of regulation for the sector, how they're similar to state regulations like Colorado that have been successfully applied and are kind of well demonstrated measures to reduce pollution. And so looking to that factual record, as Leo mentioned as well, rather than relying on a legal interpretation to support their action.
All right, thanks for that question, Monica. Thanks for the great answer, Rosalie. We still have a couple of minutes for questions. Maybe one I'd pose to our audience is, what are your concerns about this? Do you have, is there a specific area of regulation, health, environment, something else that you are worried about in light of this ruling and several others? While you ponder that, I kind of want to reflect on something that both of our guests have said today, and that is the importance of building an evidential record. And I mean, in a way, it sounds really kind of self-serving because CHI is a health policy institute, right? And it seems as though policy has kind of fallen out of fashion in the past several years in favor of, I call it vibes-based policymaking. But we see really what matters here is that what gets entered into that official record, and whatever, the white papers and the public comments that everybody in this community provides, that really does hold more weight in front of a court than do vibes. So that was just one of my big reflections from this, from our webinar this morning. I'm gonna, Emily, any reactions to that?
Yeah, I'll just share, so an example though of a space that I'll admit that I'm not an expert in, but I have been following the rapidly growing body of evidence on closely recently, is the impact of work from home policies on productivity, on corporate cultures, et cetera, because CHI, like probably every other employer on this call, we're trying to find the right balance of a hybrid work environment and how do you make it work, et cetera. And I guess one thing I will reflect on is when we have these areas, like Joe, you mentioned AI earlier, and just like how rapidly a lot of the science that we work with and the context that we work within are changing. And I think one thing that I agree that building up this body of evidence is so key. And I would say that when it comes to policymaking, especially on some of these newer topics, oftentimes policymakers move at a pace that is more rapid than academia and evidence generation, et cetera, go. And so if you have an opinion on remote work policies, you can absolutely find a study that justifies that opinion, regardless of what it is. And so I guess my reflection on what you're sharing, Joe, is yes, and I wonder, it is a lot to be asking people who, judges or, people who are not maybe experts in whatever the science that they're working within is, to try to sort through some of these potentially contradictory findings, because a lot of it ends up quickly getting into the esoteria of oh, well, what was the control group there? And what was more of the context around those circumstances? And you really have to be doing kind of this meta-analysis of the quality of that research, which is where I end up continuing to come to not just expert opinion in the development of that research in the first place, but expert opinion in the interpretation of that research, if that makes sense. And so, and the reason I bring up remote work is because it's just one where I feel like I am more of a user of that information than the generator of that research. And it's been an incredibly kind of, I don't know, almost disorienting experience trying to navigate through it. And so that's my initial reflection there.
Yeah.
Sorry.
Yeah, no, great point. All right, well, I realize a lot of our audience probably has a 9 o'clock meeting and a pressing need to refill their coffee. So thanks so much, Emily and Rosalie, for joining us today. One more pitch for hot issues in health. It is December 5th. We'll be talking about, if you got anything out of today, we'll have a lot more in this vein and far beyond the legal sphere. December 5th out at the Anschutz Medical Campus. You see the very easy web link up there on the top left, palo.health/hot issues. All one word, all lowercase. That'll take you right to the page where you got everything you need to know to register. With that, thanks everyone for your kind attention this morning. Thanks again, Rosalie and Emily.